Bah Adelbert nongrum MLA jangkasang Voice of the People Party mentaga sengi ka life potarik unailar arajar arpsau ulwara yagamat jiyatai po assembly lemba kata ka jiyatai ka baki ong ka half an hour discussion ani kata ka jiyatai ka bane kumbashi tengkenta kani kamat jiyatai ka balong ra do MLA jangkanot shalong kalong halor ka lantas part ak syakna spa nyuhui as amended lani kata ka jing penpahan ani ka amen yang ka lantas part ak syakna spa nyuhui Kadau ka Bah Adelbert wan ra ya gane kejiatai kalong namar bah ka sibo wan ra jingkeli haka bedai bat ka jing yo ala jingki barjala man yo jaka na ki try muluk nani ka transfer of land na ki tribal shaken non tribal nani na ki local director jaka na company ki bri ki try jala shaki barjala Bah Adelbert nongrum ulapan pau ka jing skopla ba ka jing skolungo ba ka por ba keli ka jingkeli ya gane na kalyang jong menteri ulang ba amla ban transfer lani ban ai ne ban dia ke jaka na ki tribal lani ne ki rulum shaki bam dai ki rulum pen ban ka sngi ka babu lawan rak lamba jaka kare jendam ka ban ka leng jaka sarkar kala juba bakila ban transfer ya ke jaka te kila ban ai ne ban ha ya ke jaka na ki rulum shaki bam dai ki rulum la kalong ka bide ki company lani ku pat ki bor na kaleng jong ba ado lapan pa ko jong smokhia yang di amendment bar ulong bangan kata shibun yang kini land transfer act umatri katat revenue ubak kerman shelah bajubab yang kini ka jenyatai ulong panadu kasam ajar shipo terter par wanadu kasam tiak na sepatnya hui terter gladon ki amendment bar ki rule ki babun ki bedai bat land transfer act tambah ulong mahabala ban ajaka ni ban transfer ya ka jaka na ki rulum syaki bamde ki rulum kita don da ki board ki bedai pet ani kita ki competent authority ki bai day lebar jong sarkar kumta ulong ba kani kajing transfer lande kajing IT ki jaka ki puta jong ki rulum syaki bam de ki rulum kam dei setia kabara amasulia kan ba mon rei de ka don di board ki bapet kanang ba kanam don kanu du ka jumpen khanya kan land transfer act
as amended, which was admitted on the day 2 of the ongoing autumn session 2024 and which appears as question number 7 in the printed list of start question for reply by Minister in charge Revenue. The first matter relates to the strange flip-flop made by the Minister in charge. When giving answer to my question at first instance, having given reply in the negative and then by the very next day, forwarding an official corrigendum from the government to completely change his reply into the affirmative. The second matter relates to the answer given as per the corrigendum, which was requested to be treated as the official response from the minister in charge, and which has turned out to be controversial and questionable in law. To give a better context to the two matters that have arisen, Mr. Speaker, sir, please allow me to bring up my start question on the Land Transfer Act and the replies made by the Minister in charge, which are as follows. A. Whether the Land Transfer Act 1971 as amended allows for the transfer of land from a tribal to a non-tribal by a lease deed. The answer given at first instance was no, and thereafter the answer was revised by corrigendum to yes. B. Whether land held through lease by a tribal local director of a company can use the land for setting up and running a factory in the name of the company where he is the local director. Here again the answer given in the first instance was no, and thereafter was revised the answer was revised by corrigendum to yes. C. Whether land held through lease by tribal local partner of a partnership firm can use the land for setting up and running a factory in the name of partnership firm where he is the local partner. Similarly, here also the answer given in the first instance was no, and thereafter the answer was revised by corrigendum to yes. Mr. Speaker, sir, anyone and everyone who has come to know about the striking change in the answer from no to yes that was made overnight will surely understand the first matter I raised in this discussion about the strange flip-flop made by the minister in charge. On the second matter that I raised, that is the answer to be treated as the official response, I would like to discuss them in light of the Land Transfer Act 1971 as amended and other relevant statutes. The official answer to whether the Land Transfer Act 1971 as amended allows for the transfer of land from a tribal to a non-tribal by a lease deed is replied as yes. Let us read Section 3, subsection 1 of the Meghalaya Transfer of Land Regulation Act 1971, which clearly states, no land in Meghalaya shall be transferred by a tribal to a non-tribal, and where in Section 2, Clause D, transfer is defined as the conveyance of land of one person to another and includes lease. Of course, Section 3(1) has an exception which states, except with the previous sanction of the competent authority. But this only implies that no land can be transferred by a tribal to a non-tribal is the norm, and that a transfer made with the sanction of government is the exception. The norms and the exception are the two different factors in law. And how do we know which is the norm? Well, we read the provision of Section 3(1) in light of the preamble to the Land Transfer Act, which state, thus, an act to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribe therein. Mr. Speaker, sir, so it cannot be implied by the official response of the minister in charge that land from a tribal can be transferred to a non-tribal by a lease deed has suddenly become the norm. The reply of the minister in charge therefore sends a wrong signal to both tribals of the state who are protective of their land being alienated, as well as non-tribal outsider who have an eye on acquiring land in the state. As for my start question, B and C, both these questions are similar in that they both relate to the holding of land through a lease deed by the tribal local director in case of a company and by the tribal local partner in case of a partnership firm. And so I shall discuss these two questions at one go because the legal implication is almost familiar or similar. Mr. Speaker, sir, now Section 105 of the Transfer of Property Act 1882 defines lease of immovable property as transfer of a right to enjoy such property made for certain time, express or implied, or in perpetuity, in consideration of a price paid. And Section 17D of the Registration Act 1908 provides that lease of immovable property from year to year or for any term exceeding 1 year or receiving a yearly rent is a compulsory registrable instrument. Hence, after a conjoint reading of the various provisions of law, it is mandatory for the lease deed referred to in my start question B and C to be a registered deed made with a registration authority in a district and not just by mere registration of the lease deed before the local traditional authority or notary public. Further, it has to be clearly understood that the tribal status of the local director in case of a company and local partner in case of a partnership firm in whose name the lease deed is made is not co-extensive with the company where he is a local director or partnership firm where he is the local partner. In other words, the Land Transfer Act will definitely come to operate in case the local director or local partner use the lease deed made out in his individual name for running a factory in the name of the company where he is the local director, or in the name of the partnership firm where he is the local partner. Mr. Speaker, sir, so the official response given as answer to my start question B and C again cannot be implied to be the norm and maintainable in law, as it is mandatory for the company or partnership firm wanting to use the land for setting up and running a factory to have a valid registered lease specifically in the name of the company or partnership firm. And that too is much dependent on whether the original lease allow for a sub-lease. From my side as a public representative, Mr. Speaker, sir, after receiving the official answers to my start question on Land Transfer Act 1971 as amended, I am now apprised that there is the great possibility that cement factories and coke oven plants and mining operations and even petrol pumps may not have valid land documents as required by the Meghalaya Transfer of Land Regulation Act 1971 as amended and other relevant statutes. Sir, with these very few words, Mr. Speaker, sir, I thank you for admitting this half an hour discussion on matter of public importance arising out of answers to my start question on Land Transfer Act 1971 as amended. With these very few words, sir, I once again thank you and all the honorable members, and I resume my seat. Thank you, sir.
Okay. Minister in charge to reply, please.
Mr. Speaker, sir, I thank the honorable member, Sri Adelbert Nongrum, for the discussion. Sir, the Meghalaya Transfer of Land Regulation Act 1971 was enacted by the state legislative in the year 1971. The purpose of enactment of this act is to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribes of the state. The act came into force on the 16th January 1972. The Meghalaya Transfer of Land Regulation Act 1971, Meghalaya Act 1 of 1972, extends to the tribal areas within the state of Meghalaya as specified in Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, subsection 2 of section 1. With the enactment of this act, land in Meghalaya, which includes immovable property of every description and any rights in or over such property cannot be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority, and any transfer of land made in contravention shall be void and shall not be enforceable in any court. Under Section 2D of the Meghalaya Transfer of Land Regulation Act 1971, as amended by the Amendment Act of 2010, the term transfer has been defined to mean the conveyance of land of one person to another and includes gifts, sale, exchange, mortgage, lease, surrender, will other than will covered by clause C of subsection 1 of section 3A, license or any mode of transfer or any authority with the conferred rights upon a non-tribal to use or to derive benefits from the land as an owner. Sir, The Act has various provisions which fulfill the intent of the legislature when it was enacted, and some of the important provisions are Section 3. It mentioned that no land in Meghalaya shall be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority. This section was further strengthened by an amendment as early as in the year 1971 by Act 1 of 1973 by adding a provision which stated that provided that the government of Meghalaya is satisfied, may from time to time by notification prohibit any transfer of land within such area or areas as may be specified in the notification, and thereupon the competent authority shall not sanction any such transfer of land under the provision of this act within such area or areas. During the course of time, this section was further amended by the legislature in the year 1991, Act 11 of 1991, which added another proviso which stated that provided further that no notification made under the preceding proviso shall apply to transfer of land for any of the purpose mentioned in Clause E of or Clause F of subsection 1 of Section 4. Therefore, sir, the two important exceptions allowed by the amendment of 1991 are Section 4(1)(e), whether the land proposed to be transferred is required as a place of public religious worship by any community or as burial or cremation ground. Section 4(1)(f), whether the land sought to be transferred is for the purpose of implementing a scheme to promote the interests of the tribals in the field of education or industry. After Section 3 of the Principal Act by the Amendment Act 2012, the following new Section 3A have been inserted and is reproduced below. 3A1. Nothing is in subsection 1 of Section 3 shall apply to any transfer of land of an owner taking place. A. By devolution and succession according to the personal law governing him. B. By way of partition or settlement amongst the immediate member of his family. Immediate members of his family means lineal descendant and includes husband, wife, mother, father, mother's brother, father's sister, son, daughter, includes stepson, stepdaughter, and adopted daughter and son or daughter of the mother's brother or sister, father's sisters or brother. C. By a will created by him in favor of his parent, legally married spouse, son, or legally adopted son, daughter, or legally adopted daughter, grandson, or granddaughter, son-in-law, or daughter-in-law. Section 4. This section lays down in detail the procedure to be followed in any matter of the transfer of land. It mentioned that in granting or refusing sanction under Section 3, the competent authority shall take into account the following matters according to the circumstances of each case. A. Whether the non-tribal holds any other land in Meghalaya. B. Whether there is any other tribal willing to take the land on transfer at the market value. C. Whether the non-tribal seeking to take the land on transfer is carrying on any business, profession, or vocation in or near the area, and whether for the purpose of such business, profession, or vocation it is necessary for him to reside in the area. D. Whether the proposed transfer is likely to promote the economic interests of these scheduled tribes in the area. E. Whether the land proposed to be transferred is required as a place of public religious worship by any community or as burial or cremation ground. F. Whether the land sought to be transferred is for the purpose of implementing a scheme to promote the interests of the tribals in the field of education or industry. This section also mandates the competent authority to record its decision in writing along with the reasons thereof. Sir, the enactment of the Meghalaya Transfer of Land Regulation Act 1971 is to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribes of the state. The transfer of the private land followed a stringent procedure which are: A. The buyer submits an application to concerned Deputy Commissioner. The application includes details such as the names and addresses of buyer and seller, description of the land, sale agreement, and other verified documents. B. Sir, upon receiving the request, Deputy Commissioner verified the legitimacy of the request and evaluates the proposal in accordance with the provisions laid down in the Meghalaya Land Transfer Regulation Act 1972. The proposal is then forwarded with recommendation to the Revenue and Disaster Management Department for approval. And on further examination of the proposal or request, and if it is deemed appropriate and in accordance with the provisions laid down in the Meghalaya Land Transfer Regulation Act 1972, the proposal or request is approved by the competent authority. Sir, the reason, as have been heard from the honorable member, he mentioned about the answer that we have through the corrigendum that we have changed from yes to no. So there's a reason for it, and as per through proper act and through proper direction, we change it. And at the same time, sir, the reason that all this transfer has been followed as proper procedure, sir. If there is any transfer which has been transferred to any other non-tribal or even within the tribal itself, sir, I would like to request through you, sir, all our colleagues here, if there is found that there's a guilty from our department, we are here to find ways how to correct it. But till that, sir, I really appreciate that our ancestor who introduced this Land Transfer Act is really serve the purpose of the tribal people of our state. Till now, that's why we have seen that all the lands has been remained here, and nothing has been transferred to a non-tribal without the purpose for the interest of our people. So, sir, in conclusion, sir, I would like to mention here, under Section 3 of the Act, along with amendment from time to time, it has to be read in totality to avoid the confusion. Each and every case of land transfer within the purview of the Act has to come to the Revenue and Disaster Management. Sir, it is clear that the government, while processing any case, transfer, mutation, mortgage, will extra, proceed as per the provision laid down in the Meghalaya Transfer Land Regulation Act 1971, Act 1 of 1972. And the Meghalaya Transfer of Land Regulation 1974, and I would like to impress that the intention of the government is very clear on the matter of transfer of land, that the Act and rules are followed in letter and spirit, so as to protect the interests of the tribal of the state. Sir, this is my answer, and I believe the honorable member satisfied with this answer, and with this few submissions, sir. I resume, sir. Thank you.
Bah Adelbert, do you wish to seek clarification? Maybe one?
Yes, sir. Only one clarification, sir. Thank you, Mr. Speaker, sir, for giving me this opportunity. Especially thank you, Honorable Minister, who had give his replies on this very vital issue, because it is a compulsion, as land and life is the same. Once we lose, we cannot expect to get again. As these two example, land and life is like the two sides of the same coin. So because of this reason, it compelled me to brought this, to request your esteemed office to allow me to move in this half-hour discussion. I would like to seek only one clarification from Honorable Minister in regards with cement factories, coke oven plants, mining operation, and petrol pumps. Whether all these have a valid document, a valid land document according to the Meghalaya Land Transfer Act 1971 as amended.
Yes, sir. As have been mentioned, there is a procedure to be followed. The buyer submit an application to the concerned deputy commissioner, and then the deputy commissioner, after verified then the proposal has been forwarded to the revenue disaster management. So, in our departments, for approval and for further examination of the proposal request, it is deemed appropriate. If it is deemed appropriate and in accordance with the provision laid down in the Meghalaya land transfer, then only we approve, sir. So that is the procedure need to be followed. So we have followed that.